Hello, I'm Nora Hanna, Chief Engagement Officer at Sun Health, and I'd like to welcome you to this episode of Coffee Connections. We created this series to bring you the most current and relevant information on topics that matter most to you as you do critical planning for your future, and to connect you with the preeminent subject matter experts so that you can make highly informed decisions that are right for you. Our mission is to empower others to live longer, healthier, and more purposeful lives. So we're excited to be able to offer you this unique access to expert resources. Thank you for joining us and enjoy the presentation.
Thank you, Claudia and Sun Health Foundation, for extending an invite to co-present at the beautiful community of Colonnade. As previously mentioned, my name is Lena Gardea, and I work for Bankers Trust Company as part of our Wealth and Trust division. In my role, my primary area of focus consists of trust and estate administration, along with investment management services. For my portion of the presentation, I will be discussing considerations to keep in mind when you are choosing between hiring a professional trustee versus an individual. As you can see behind me, our first slide shows what's the difference. This is a question that comes up quite often. And so part of this presentation is educating the community so you understand some of the differences and some of the considerations to keep in mind when you're making this decision, as it is a very personal decision, but one that will overall impact your estate and your financial needs. So one of the first questions that typically gets brought to my attention is, how does the trustee step in first? In understanding the first step, it is understanding what the role is. In other words, you have been given the responsibility to administer this trust in the following areas, such as banking, investments, physical property, and taxes, just to name a few. So a lot of times people will try to figure out, well, is this something that they can DIY themselves when they're taking on a role for trust administration? And so when you are deciding whether to go with a professional or an individual trustee, a question you should ask yourself is, does my trustee have the knowledge, the background, the skill set, and or time commitment to carry out the required tasks? I have pulled together a short list of some of those tasks. So let's start with banking. Banking is the first immediate need when you're dealing with a trust or an estate. And so some of the things to keep into consideration are accessing the account. Will your trustee know how to access your accounts, know where they're located? Do they understand the different sources of income that come into your trust or your estate? Understanding funds that need to be paid back when you pass and they're settling estates, such as overpayments of public benefits, clawbacks. There is a time in place when you are the trustee about understanding how retitling works on your bank accounts, your investment accounts. This would lead me into investment management and another consideration to keep in mind for your DIY if you choose to have an individual versus a professional. How will your trustee manage the risk of the portfolio during changes in the markets, the economy, and interest rates? These are considerations that when you're talking about the investments that are in trust, you're going to want to think through. Will your trustee understand the significant tax consequences of investment decisions within the portfolio? Another question you want to keep in mind is, can your trustee align the proper asset allocation to match the needs and goals of the portfolio and beneficiaries? A lot of time beneficiaries have different needs. There might be charitable causes, there may be individuals, and so you want to be able to know that your trustee is going to be able to effectively manage those needs and not, feel overwhelmed that you've got charitable needs, but then you also have individual beneficiary needs. Another question to take into consideration is, can your trustee take the emotion out of decision making while managing investments during volatile markets? We all see the news. Some days it's great and some days it's not so good. And we want to make sure that the trustee that's managing these investments understands that there will be bad news days. But correlating what you see on TV to the market is definitely something that you want to take from an objective perspective and not an emotional one. Another consideration to keep in mind is financial planning. Understanding the relationship between the portfolio, the taxes, the estate plan, income needs, and goals of the beneficiaries. This kind of brings me back to the initial comment I made. Knowing the difference between your charitable needs, your individual beneficiaries, and in certain cases where there's sub-trust and there's ongoing either gifting or charitable causes, what that's going to look like for each beneficiary. The big thing that a lot of trustees, a good trustee will take into consideration is making sure to put a plan in place. This reduces risks and optimizes growth and tax-efficient strategies, helping to avoid pitfalls that many inexperienced investors or trustees are prone to make. Understanding the cash flow needs. Part of being a trustee is also understanding the wealth planning and, to a point, retirement accounts. Although we have financial power of attorney to help with some of these things, it's a bigger picture when you're talking about a trust. That brings me to neutrality and continuity. This is a very, very key decision you want to keep into consideration when you're deciding whether on a personal trustee or a professional. So let's talk about the definition. The definition of neutrality is the state of not supporting or helping either side in a conflict, disagreement. It is impartiality. When choosing your trustee, can they and will they be impartial when conflict arises? In my role, part of what I do is the corporate trustee, and that is one of the best questions that anybody who's interviewing me can ask. And I would encourage you to consider that being a primary question when you are interviewing someone for this role. What happens should conflict arise? Because you know your family dynamics or the dynamics of the beneficiaries better than anyone else. When I get calls from potential future clients who are interviewing me as their successor trustee, when I'm asked that question, how do I handle conflict amongst beneficiaries? The general rule of thumb is to always follow what the governing document says, which in this case would be the language of your trust. Your trust document lays out how conflict should be handled, but when the language is vague and or is considered discretionary in nature, we have a committee process to handle these types of requests and or disputes. So that's a piece of the logistical process you'll want to consider when you're deciding between an individual versus a professional. Most professional fiduciaries, corporate trustees have some sort of process in place to manage and mitigate disputes or any type of conflict amongst beneficiaries. Will the individual that you're choosing be able to have some sort of process in place or something to reflect something similar should the dispute arise? As a corporate trustee, we have many process procedures in place to ensure we honor a fair and neutral position across the board for all beneficiaries. And so this will bring me to working together. This is a team concept. There is not one person in your estate plan that can handle it all on their own. And so when you're choosing a trustee, another great question to ask yourself and to put at the forefront is how will they work collaboratively with the other parties that make up your team? To give you a couple examples, your team may consist of the following: financial power of attorney, medical power of attorney, mental health care directive, guardian, conservator, CPA, trust protector. The list can go on and on from here. And so what you want to know is, can your trustee effectively work with each of those roles? And do they understand what those roles mean? A lot of times people get confused between a financial power of attorney and a trustee. The difference with those is how assets are titled and what each document represents. And so the position of one role versus the other means that they may have to work collaboratively together to get the financial estate or plan across the finish line. But it doesn't mean that one role supersedes the other. And so understanding when that needs to work together, understanding when to work with the attorney. If there's charitable causes in an individual's trust or an estate, understanding the charitable reasons, understanding the charities that you're going to be working with, and how to make sure that those needs are going to continue to be met, even if you should become incapacitated or you're unable to make those direct contributions yourself. The other piece I always tell people to keep into consideration is the guardian role and the medical healthcare power of attorney. Although those roles don't typically deal with directly finances, they're there to protect the quality of life for the individual. And so part of the financial piece of that on the trustee's part is making sure that when they're talking to your medical power of attorney or your guardian, is making sure that medically they're also meeting your quality of life standards. And so with that, I want to leave you with this one last question, or consideration, I should say. Remember, when you're choosing the right trustee, this is a personal decision, but one in which should be decided with the utmost care and consideration. And with that, I will turn this over to Daniel Esparza from Lincoln and Wenk. Thank you.
Thank you, Lena. Wow, this is louder than I thought. Thank you, Lena, very much for that presentation. Always interesting content, as always. I'll try to follow that up as best as I can, and explaining those intricacies that can come into this difficult topic of choosing a trustee. It's a very interesting topic because it actually involves maybe a little bit more than you might expect. A mixture of both legal and practical considerations in particular. So you have to think about human dynamics, relational dynamics, legal considerations on who can do something, what are the responsibilities, and such. So in order to delve into this, I thought that I would put together some stories that illustrated some of the legal situations that might come up, as well as the practical considerations that might come up with maybe more than one trustee working together, different situations that weren't expected, and that sort of thing. So I'll start out by just briefly talking about my background so you know the perspective of which I come from, because that does affect how we evaluate things. And a brief overview of where this all fits into the legal system so that you know where we kind of end. Some of it Lena talked about. And then finally getting into the stories and illustrating where it is that everything is. Right. Okay, so real brief before getting into that, I'm actually going to give a few of the mandatory disclaimers. This is general legal advice, or general legal statements on the general state of the law. It's not individual legal advice. If you want to discuss this, it'll be available afterwards. We also have a question session. But make sure that you do see an attorney in person and one-on-one to make sure that you discuss your individual situation. Secondly, that these are real things that have happened, and with some modifications to make it a little bit easier to understand and to keep people's identities a secret. Of course, attorney-client privilege is very important. However, they are real and they can happen and have happened. So briefly about my background, I have both a JD and an MBA, which I was fortunate through the Maurer School of Law in Bloomington, Indiana University's School of Law, I was fortunate enough to have a dual program through their partnership with Sungkyun Kwan University in South Korea, where I got my Master of Business Administration. So I didn't know how this would exactly help me in the future as much as it did. But getting to look at things from both a legal and a business background helped me to get a grasp of practical considerations, and that's where I branched out into estate planning and business law, which later I added probate and guardianships. Now I say this just to say how I look at things. That I look at things from both what is going to possibly happen in court and from the peremptory area of looking at the documents and making sure that things are clear. There are so many things, or lack of clarity can result in serious problems. Having too much discretion, not enough discretion, those kind of things for a trustee. So the way I look at estate planning is I look at it like a toolbox. Many of you would be familiar, of course, with this. Either you or your significant other probably had to repair a lot of things at home or still do. And like any toolbox, it's got some basic things in it. It's got a screwdriver, maybe a drill, hammer, but you'll see different types. I mean, you're not going to use a Phillips maybe when a flathead fits better, or vice versa, right? So you'll have these similar documents in all of your estate plans, but they're going to be a little bit different, and it's those differences that really make a difference. So this can be a whole other presentation in and of itself, and we're not going to go into the weeds of this thing, but what I want to point out is this. There are two main areas that are dealt with in every estate plan. First, financial decisions, which can be before death or after death, and then medical decisions. So you have a trust, you have wills, and you have financial power of attorney. Those allow people to make decisions for you or for your estate or trust, again, before or after death. Totally separate from that, and often different people serving in those roles, is medical powers of attorney, which is akin to a guardianship if it was in court. Those are two very different considerations. What we're going to talk about here is finances. It has its own unique way, own unique worries, own unique concerns, and sometimes more difficult. It's to illustrate, a financial power of attorney requires a witness and a notary to be valid, while a medical power of attorney only requires one or the other. You can see how the law is very concerned about money, and that's because you have people trying to take advantage in a unique way that doesn't come up with medical matters or guardianships. Although that does happen, but like I said, different. So I came up with 3 examples of things that have happened all relatively recently. First, a situation where there were co-trustees who didn't get along, and this was, in my opinion, asking for trouble from the very beginning. Declination to serve by a trust company, which brought about its own unique concerns, and a situation that happens, it's not going to be the last one, it happens more often than you think, where someone is appointed as trustee who was never had any intent of accepting the trusteeship, even if it was a company, but it's a common misperception that that person or entity would be appropriate to serve in that role. So starting out, I'll say this really quickly. I know you all can read. The situation was where a person named I'll call Patricia has a son and a stepson. She was also married, but her husband had dementia. So he was not able to manage things without her. Now the son and stepson did not get along. It is unfortunately common in mixed families. But Patricia established a trust and appointed her son and stepsons as successor co-trustees with, importantly, the requirement that they both agree before any action is taken. Unanimity was required. Patricia later passes away, leaving her husband as the trust beneficiary. So that part's good. Of course, the husband is expected to be the one taken care of. But the 2 children, again, they didn't get along before. They're not going to get along now. And this is a really serious problem because they have to both agree for any action to be taken. Otherwise, everything is just at a standstill. And that's exactly what happened. What's happened in this case is it ended up going to court. And there really was no other way to do it. It had to have a conservatorship established, which is like a guardianship, but it's over money. And there's actually some things that are still not quite certain of what's going to happen, but that's the only way that this person could be taken care of with his own finances. So that's a consideration that you really want to take is, are these people going to get along with each other? And don't think just forcing them to get along with each other by saying do this or else is going to help it. It just might not. Secondly, an example, this is a very common example, and it's because sometimes life just happens. So we have Suzanne, who is a widow, established a trust. ABC Trust Company was nominated as the co-trustee along with her son, Mark. Suzanne passed away, and ABC has a minimum, has a minimum asset requirement in order to serve as trustee. Almost all of them do, but you never know really what it's going to be at the time of death. Suzanne's trust has an asset value under that minimum, and so ABC Trust Company declines to serve as the trustee, leaving Mark as the sole successor trustee. Now, in this case, this wasn't that bad, but it was only out of luck. So Mark was very cooperative, able to seek other guidance to help run the trust. But one way or another, it didn't. Suzanne's wishes were not followed. It wasn't the way that she planned this. And what would have happened if Mark wasn't suited? Maybe he needed guidance because he couldn't manage his finances in a prudent way and would therefore be left without anything. Let's say if he didn't have any other income because of medical needs, then what would he be left with if he spent all of his money? I'm happy to say that Bankers Trust actually addresses the situation very well. They will work with the trustee or whoever the interested person is to find a cost-effective method of carrying out the decedent's wishes in the closest way possible. And you want to have that kind of flexibility, first of all, because situations do change, and maybe it's just not at this time financially a good idea to have a trust company handle this. The cost-benefit analysis might be different. And so, for example, one thing that could happen is that by a non-judicial settlement agreement, meaning not in court, which is where a trust is really for, it's for keeping things out of court, it's one of the main purposes, agreeing for a private fiduciary to come into place, which is someone who might be suited to a smaller estate or smaller trust, while still having Bankers Trust act as the investment advisor or financial advisor. And that's because Bankers Trust still as an investment bank. I believe that's a technical term for it, but they do handle investments. They are suited still to managing this, but maybe it's better for them to focus on that role and leave the other role to someone else. Whatever is best for the trust beneficiaries is the rule of the game. Finally, we have Paul and Dorothy. They were both married without children, so not your traditional pool of people to choose from in being trustee. They establish a trust and nominate the Salvation Army as successor trustee. Paul and Dorothy both pass away, and the Salvation Army is contacted after learning of the death. The Salvation Army, however, declines to act as trustee per their policy. So a new trustee has to be voted in by the multiple non-charitable beneficiaries. This particular trust had a lot of beneficiaries that were charities. We had to look into the terms of the trust and see who was allowed to vote for a new trustee. That is one of the ways of appointing a new trustee. When there is no other alternate, then there was no other alternate besides the Salvation Army. That was expected to be the one acting as trustee. But a vote had to be taken in order to fill in this vacancy. Fortunately, it did not end up in court. Fortunately, this was able to be done, but it was very tricky finding all the people that needed to vote on this. And it was time, money, and just a lot of unnecessary things to get that done. And so it's important to, when you're say going and making a trust, that you're talking with someone who knows some of these considerations, like, oh, I've seen this before, I've seen the Salvation Army. They're a great organization, but they do not do this. And it probably is not a good idea for them ever to do it because it's not in their competency. So definitely things that you want to keep in mind. And finally, I'll just close real quick, leaving this something that I like to share a lot and remind myself a lot of what the role of an attorney is when looking at all this. It's to facilitate the expedient and efficient settlement of a trust or estate. It's to make sure that good is done. Abraham Lincoln, one of the greatest presidents we had, probably why he was such a good president as a lawyer, he had this philosophy of not fighting when it's not necessary. And this is something that these are fights that can be avoided by choosing the right trustee, by choosing a professional when it's appropriate, and choosing the right professional when it's appropriate. And so I thank you very much for your time here today, and I'll turn it over for the next section.
Thank you, Daniel. Thank you, Lena, for your insightful presentation. Today, as we heard, we emphasize the critical role of selecting a trustee who acts as a guardian of your intentions, ensuring they are faithfully executed. So, given that Sun Health Foundation is often named as a beneficiary in estate plans, we thought it would help to present a few examples from our experience to illustrate what can go wrong when plans do not unfold as expected. So let's start with a first example. A couple of years ago, Sun Health Foundation received a large donation to support nursing scholarships. The trustee was essential in maintaining the scholarship's integrity and effectiveness. Unfortunately, when the trustee passed away, a portion of the trust remained undistributed. The successor trustees were unable to serve due to incapacity or unwillingness. As a result, Sun Health is now navigating the challenging and costly process of appointing a new trustee and finalizing the distribution. So let's ask Lena, how could this situation have been avoided?
That's a great question, Claudia. So a couple things to consider when you are choosing a nomination for a successor trustee is making sure your trust document is updated regularly to reflect your wishes of which individuals you want chosen. Selecting second and third nominations, backups. Also making sure that the trustees you're selecting want to take on the role. A lot of times we nominate people for various personal reasons, but that doesn't always mean that the individuals who are nominated have the time or the capacity to take on that role. And so you always want to make sure there's some backup. A lot of times I've heard that putting some sort of corporate last option trustee as a successor trustee role is very helpful, because one thing that's consistent about a business is it will always be there versus an individual who may not.
Great, thanks, Lena. Very helpful. So stay on top of it, be proactive. Makes sense. So for our second example, thank you. We recently lost a valued legacy donor. Sun Health Foundation was to receive a substantial donation from their trust. However, the designated bank declined to serve as a trustee and personal representative. With no successor trustees appointed, this led to delays in fulfilling the donor's wishes and increased legal expenses. So now I'd like to turn the question to Daniel. What steps can people take to prevent this and ensure their trust is in good hands?
Well, there are a lot of things that can be done to try to foresee the circumstances happening, having alternates in place, because you never know the circumstances that might happen. You're trying to predict, say, 50 years in advance or even more at some times. So having alternates is a good first step. Also having a good mechanism to appoint someone else, maybe a trust protector if you have a smaller pool of people that might be fit for handling this, a smaller family, for example. A trust protector, again, maybe appointing an entity in that role, like a law firm, would allow at least somebody to be appointed if there's no one to vote on this, or it's hard to contact them. And then just plain having reviews. I think making sure that you keep up on things doesn't mean that you have to redo your whole estate plan, but pull it out of the safe once in a while.
So again, it's just reviewing, staying on top of your paperwork, and making sure that things are always current. Thanks, Daniel, for that. Now I'd like to share a third example. A donor allocated a substantial sum to a charitable fund with specific intentions. However, 2 decades later, the designated fund no longer exists. The charity must now determine an appropriate fund for the allocation while ensuring that the donor's original wishes are still honored. So in this example, the question is, how can you ensure your wishes are honored when making charitable contributions? So I'm going to take a stab at that one. As a charity representative, I'm happy to answer that from our perspective. So to ensure that your wishes are effectively honored when making estate gifts, consider the following steps. Have regular communications with the foundation. Stay informed about any changes in their fund structure or priorities. Regularly review and update your estate planning documents. Reflect any changes in the foundation structure or your own wishes to keep your gift aligned with your goals. Include contingency plans. Work with your estate planning attorney to specify alternative uses for your gift in case the original fund is no longer viable. Daniel, what would you add to that?
I would add that those are all great things, particularly the idea of a contingency plan. That's the main thing. If you list an entity in there and that's the only thing it is, it's very hard to change that. But you can, again, say if this entity is not in existence, then this or that. If you don't, the last option would be the court system. There is a doctrine called cypress, which means that the court can modify for charities, modify the trust to allow it to go to another organization of a similar character. But that's, of course, you don't want to do that, but at least there is a way to do this, and those are usually at least less contentious than other situations.
Thank you, Daniel. So hope these examples were helpful. Now we'd like to open the floor. Maybe you all have questions that you've been thinking about, regarding trustees, updating your estate documents, or charitable giving. Can a person that is appointed as a trustee also be a beneficiary?
Yes, absolutely. They'll have considerations that they need to think of. For example, conflicts of interest. But it's actually very common for that to be the case. They just need to make sure that they're following all the rules. Yes, follow the rules. They need to make sure they're following all the rules, and try to have agreement as much as possible, especially when making distributions.
What is the difference between a trust and a will, and what would happen if none of those were in place?
A trust is, let's see, I'll get not so technical about it. In its essence, I like to think of a trust, it is a company. It is technically, a trust can own, let's see, land, for example, it's very common. But like many other companies, there's so many things. There's a hardware store across the street, and then there's Coca-Cola. They're maybe same kind of formation or similar, but they're very different in how they act. That's why trusts are used often. They're used often in estate planning because they're so flexible. For example, you can make a trust that just holds all your assets and does that to avoid probate. Because if the technical owner of an asset is the trust, like say a home, when you pass away, the owner is technically still the trust, so there's no probate that's triggered. That's a simplified way of looking at it. So in that case, the next trustee, because there's instructions that are in the trust of what to do next, the next trustee can simply distribute that property without going to a judge to have that done. A will is you acting as yourself in giving directions upon your death for anything that you have in your name. So a trust is often known as a will substitute. It's not really, but it does do a lot of what a will would normally do. But a will is there, and even should be there with a trust. It's there for anything that's in your name and saying what to do. Thank you. If you don't have either one, because some people need one, some people need one or they need two of them, at least the will. If they don't have one, then the laws of intestacy, meaning without a will be followed, and we really don't know exactly what will happen until the moment of death. It depends on if you're married, if your spouse has kids, if you have kids, all that sort of stuff. But with a will and or a trust, you can take that answer into your own hands. A beneficiary deed, does that allow for avoiding probate? Yes, if it's done correctly and the people who are listed in it are alive. A beneficiary deed is where you list specific people, like maybe on a bank account, you could do the same thing, list people to receive your assets when you pass away. And that does avoid probate. Those are specifically called non-probate transfers. A beneficiary deed is similar, but it's much less flexible than a trust. So when you're actually looking then at the beneficiary deed at time of death, you have to make sure those people are actually alive. Were there any contingency beneficiaries listed? And maybe were they minors, in which case maybe they can't receive it in the same way? Those kind of things. So it depends.
Great question. So the question was, because as age comes about and you choose a trustee that is similar to your age, what happens if you outlive them? And then who do you have? So funny story, because of my age, I get a lot of people who like the fact that I am much younger than them. The concept is I'm supposed to outlive them. But to my point earlier in the presentation, when you choose a corporate fiduciary, private fiduciary, those are entities, and entities go on for the life of the business. And so whether it's me or another individual, you always know that as long as the business is functioning and serving still as a trustee role, that's kind of a safeguard for you to consider when you're deciding on a professional versus an individual. So great question, but that is very, very solid answer, hopefully, for you. And I do think that it's a really good safeguard to have, even if you've got 3 or 4 trustees that are relatives or individuals that you think are going to serve and want to serve. It's still a good catching net, I think. So hopefully that answers your question. So the question was, what are the costs associated, and can you include that in the trust document? I think this is going to be a 2-part answer between Daniel and I. So from the corporate trustee perspective, there's typically, and I can't speak for all businesses, but I know for us at Bankers Trust, we have a fiduciary scheduled fee that we can provide clients or prospects who are interested in understanding a little bit more about that. Most institutions that I'm aware of, even with private fiduciaries, offer some sort of fee schedule that gives you an idea of what the administrative cost if you were to go with their institution. But in terms of the fees on the trust side, I'll let Daniel answer that.
So yes, that is what my experience is too. Usually there is some kind of a fee schedule. It's often mandatory for that to happen. I think it might even be just plain mandatory to have those if you're in a private fiduciary or trust company position for licensing and otherwise. I've seen different ways of like a percentage being listed. I've seen hourly rates listed, and that of course does vary. There are reasonableness standards, at least on the private fiduciary side. That's more directly involved with the court system. See, there was another. Oh yes, the default in law is that it is a reasonableness standard. So if there is just an individual trustee, then they're at least entitled to reasonable compensation, which can often be $25 to $50 an hour for just a basic non-professional trustee. And that number, it's determined by the court if it ever gets to that position.
So the question was about services and what the trustee or corporate trustee can do. Well, so in my role, I would be performing under the corporate trustee role. So I work for the bank, and the bank employs me, and the bank lists out what type of services in terms of administration that we can provide. Based on those services is how I, as the individual, go in and help a client. So for example, and I'm just using this because this is the question, if Bankers Trust was to come on as a trustee, successor trustee, I typically meet with the individual who is looking to nominate us, and we go through what kind of services they're looking for. And we talk about investment management, financial planning, administrative, all the way from paying bills to home visits to what the specific needs of the individual are. And we figure out whether or not that falls in line with what the services that we offer. So there's not a direct catch-all or 100% answer here in that scenario. It's something specific to each family, and so usually we meet with those individuals to see if we are the right fit for them. But that's where those conversations are typically had. But in terms of the term corporate trustee is what my bucket falls under, but because I'm employed by a bank, that's where that comes in. But if anyone wants to know, yes, I do administer trusts. I do help clients from start to finish, settling estates. I actually am an active role. It's not just a title. I do go out and meet with clients. So the minimum is that we don't have a specific minimum. That would be something, again, we'd need to talk about. We're a very relationship-based bank, and so we want to make sure that the needs and services are the priority for the reason that we are providing services. We don't necessarily look at something and say, oh, you have not enough money or you have too much money. We like to, meet with individuals, sit down, talk about what your needs are, and figure out if our services are going to add the most value to your estate, because that's really what you want in a good corporate trustee. If you decide to go down that road, is will the services meet the needs and are the expectations aligned with what you have?
Something to that. Yeah, I want to say that is not that common in a good way to be so relationship oriented. That's why she's on COPA, Council of Professional Advisors. And I've liked the fact in getting to know Lena and Bankers Trust better, that they do take such a personalized approach and even have in their own, as I mentioned earlier, in their own procedures, backup plans. Because what if it turns out, because you never really know until date of death. You try to predict, but you never really know until date of death what the situation is. Maybe the situation is not best for them. And that's by far not the most common thing. We're talking about some outstanding scenarios to make you think a little bit more. But the fact is that they will not just leave you high and dry like this other situation kind of had a little bit. They'll work with you. They'll work with your successors to make sure that your will is carried out as best as possible.
All right. Thank you again, Lena and Daniel. What an informative presentation. And thank you for all your great questions.
To learn more about Sun Health Foundation initiatives, become a donor, or attend a future Coffee Connections event live, please visit us online at sunhealthfoundation.org or call 623-471-8500. Sun Health, empowering people to live longer, healthier, and more purposeful lives.